Good morning, students. Today we are going to continue with the same chapter, chapter 6, joint stock company, but we are going to discuss about the different subtopic part 3. First we'll move on with classification of companies on the basis of control. So far we saw classification on the basis of incorporation, then classification on the basis of membership, then classification on the basis of liability. Now we are going to see about classification on the basis of control. On the basis of control, we are going to see about government companies, holding companies and subsidiary companies. First, let us move on with government companies. Government company is a company which is incorporated under the Companies Act 1956. So, these companies are owned and managed by the central government or the state government, or by both central or state government, or partly by central government and partly by state government. So section 617 of the Companies Act 1956 defines a government companies is any company in which not less than 51% of the paid up share capital is held by the central government or any state government or governments, or partly by the central government and partly by one or more state governments. Students, as already explained, the company will be started only with the help of the capital. So the capital introduced may be by the central government, that too 51% of it. Suppose for example 2 lakhs or 5 lakhs or normally 10 lakhs if they are investing, means from the 10 lakhs, that is 51% out of the 10 lakhs will be invested by the governments, that is either by the central government or by the state government. Then only it will be termed as government company. The subsidiary of the government company shall also be treated as a government company. That means the subsidiary company in sense the company which is under the government company, so that is termed as subsidiary company. So these companies are registered as private limited companies, though the management and their control vests with the government. Which company? The subsidiary companies. So these type of organizations where both the government and private individuals are shareholders, sometimes these companies are called as a mixed ownership companies. Why it is termed as mixed ownership companies? Since ownership vests with the hands of the government as well as the private persons. So the control is in the mixing of both of them. Okay. So that only it is termed as mixed ownership companies. Next we'll move on with holding companies. As per section 2, subsection 87, a subsidiary company or subsidiary in relation to any other company means a company which the holding company controls the composition of the board of directors or exercises or controls more than one of the total share capital either at its own or together with one or more of its subsidiary companies, provided that such class or classes of holding companies may be prescribed, shall not have lawyers of subsidiaries beyond such numbers as may be prescribed. Suppose if there are two companies, for example A company and B company. B company is running at a loss, continuous loss, continuously for 2 to 3 years, continuous loss only. So normally it cannot do its business properly. So what they will think is the A company can take the entire control of the other B company since it is running at a loss. So in such a case, when a company takes over the other company, the company which is being taken over by a company is termed as subsidiary company. And a company which takes control over a company, that company will be termed as holding company. Here in this example, I have told two companies A and B. So the A company will be a holding company and B company will be the subsidiary company. But the rule here specifies that 50% of the shares must be held by the holding company. Then only it will be termed as a holding company. So the other company normally said to be subsidiary company. So this is the meaning of holding companies and subsidiary company, students. Next we'll move on with the classification of companies on the basis of nationality. So on the basis of nationality, it has been divided into 3: domestic companies, foreign companies and multinational companies. So you may wonder, what is the difference between foreign companies and multinational companies? Both are same only, no? No, students. Foreign companies are different from multinational companies. Let me explain it one by one. Domestic company is a company which is started, incorporated in India. So it will not have a place outside India. So it will be running only in India. So it is termed as domestic company. And what is meant by foreign company? Foreign company means it will be incorporated outside India under the law of that country. So after the establishment of the business, the following documents must be filed with the registrar of companies if that company wants to be registered in India within 30 days from the date of establishment. So, a certified copy of the charter and statutes under which the company is incorporated or the memorandum and articles of the company translated into English. So, you may wonder what is memorandum of association and what is articles of association. So, memorandum of association means contains with the internal rules and regulations of the company which it has to follow during the formation of a company. But articles of association means after starting the company, what are the duties and responsibility of the members of the company that will be prescribed in articles of association. Next, the full address of the registered office of the company should be given. Then the list of directors and secretary of the company will be mentioned. Then the name and address of any person resident of India who is authorized to accept on behalf of the company service of legal process and any notice served on will have to be furnished. Then at last the full address of the company's principal place of a business in India that also has to be specified to the registrar of companies. Next type of company is multinational companies, that is MNC. So MNC is a huge industrial organization which operates in more than one country. So it carries out production, marketing and research activities on international scale in those countries. Also seeks to maximize profits world over. So a domestic company or a foreign company can be a MNC. How it is possible? By organizing more companies in different places, in different countries. So example, Microsoft Corporation, Nokia Corporation, Nestle Coca-Cola International Business Machine, Pepsico, Sony Corporations are the examples of MNC companies. So normally Nokia Corporation started in India, but it has different companies in different places of countries. With this, we are completing with different types of companies. Next, we'll move on with Memorandum of Association. Memorandum of Association is a legal document prepared in the formation and registration process of a limited liability company. Limited liability means it is opposite to unlimited liability. So, unlimited liability, as we saw, the creditors can recover the debts from the debtors, even from the private properties. But here in case limited liability in sense, the shareholders will be liable only up to the value of the shares they have bought. Any act which is done against the memorandum of association is said to be ultra vires and the company is not binding on it. Binding on it means it is not going according to the memorandum of association. It is the constitution of the company in its relation to the outside world. It is a public document or any person dealing with the company is presumed to have sufficient knowledge of it. It is the primary document of a company. Next, we'll move on with contents of Memorandum of Association. So first one is name clause. Name clause means conditions. While selecting the name for the company, it has to require to the state the legal and recognized name of the company, and the company name is allowed to be registered if it does not bear any similarities. Any similarities means it should not resemble the name of the other company, any other company which is prevailing in existence. Next clause is situation clause, that is condition. So situation means where it is situated. So the registered office clause requires to show the physical location of the registered office of the company. So where the company is situated and where the registered office of the company is situated, everything must be prescribed. It is required to keep all the company registers in his office. The registered office should be established prior to commencing business activities. That means before the business to commence, before the company could carry on the business, it has to be furnished with the registered office, the situation where it is situated. Next, we'll move on with the objective clause. Objective means main motive of the company. So before establishing the company, what is the main motive? For what they are starting the company? Everything has to be furnished. Next, we'll move on with the liability clause. So this conditions should state that in which shareholders of the company are liable to the debt obligation of the company. In case what? In case of winding up of company. So the company is limited by shares and the limited by guarantee. Everything should be prescribed in the liability clause. Next, we'll move on with capital clause. The capital clause here has to specify about the share capital of the company and also has to specify about the company's assets in this clause. Next, we'll move on with association clause. So association clause here refers to the shareholders should be bound by the memorandum of association, and also they have to associate willingly in order for the forming of this company. After filing everything, it is required 7 members to sign in the memorandum of association for a public company and not less than 2 people for a private limited company. The signing must be done in the presence of witness who must also append his signature. Append means to add something against the signature. These are the clauses of Memorandum of Association, students. With this session gets over. We'll see tomorrow. Thank you, students.